Just while people are dialing in, just a note about the format. So we invite everyone to submit any questions that you have through the Q&A or through the chat button at the bottom of the Zoom. At the end of the session, we'll be opening up the line, so you'll be able to submit basically ask any questions directly to us. And you'll do that by clicking the raise your hand button, and we'll get notified and we'll be able to allow you to speak. Everyone will automatically be muted throughout the session. And we'll give it another 30 seconds or so before we get started. All right, why don't we kick off? So thank you everyone for joining today's AFA's 101 webinar. My name is David Falstein, so I head up our client strategy and success team here at PERSUIT. I have a background in legal with a focus in law school on legal pricing. And I'm really, really excited today for today's webinar because we have an absolute expert in the legal space, Ken Callander. Ken is the managing principal of Value Strategies, which is a consulting firm that works with corporate legal departments. His specialty is transitioning clients from hourly fee pricing to value-based fee arrangements. And this provides legal budget predictability. It eliminates invoice review, and it reduces client spend by an average of 20 to 50%. So some huge savings. Ken's current clients include some of the largest companies in ride sharing, money transfer, social media, and internet search, along with multinational conglomerates and the largest university system in the US. As the founder of Value Strategies, Ken was the head of legal operations and chief of staff to the general counsel at Uber. And prior to Uber, Ken actually ran a law firm as the CMO and head of VD for Davis Wright, which is a 600 attorney international firm. He was also, before that, the marketing ops exec at HP, where, not surprisingly, he was an expert in pricing of professional services. Ken graduated with a degree in physics from Stanford and is a certified pricing professional, currently living in San Francisco. So we couldn't be more thrilled to have Ken on the line. So Ken, thanks so much for joining us.
Thank you, David.
I'll go ahead and start sharing my screen here. And just another reminder for the audience as we go along, please feel free to submit any questions that you have through the Q&A button or through the chat. If you have the ability to join on your computer, that would be ideal because we'll be launching some live polling throughout the webinar. And then at the end of the session, we'll actually open up the line so that people can submit questions to have a direct question to us on the phone. If you need to ask any questions on the phone, you're just gonna go ahead and click the raise your hand button. So with that, we'll go ahead and get started. So to begin with, we'll cover hourly rates. So we'll go over Ken will tell you a little bit about the advantages and disadvantages of hourly rates. And then we'll go into a variety of different fee arrangement models, both hourly based models and value based models. And Ken will tell you some of the pros and cons of each of these models. And then we'll conclude with talking about some really unique value-based arrangements, some of the principles of value-based arrangements, as well as a little bit of an understanding of what types of arrangements you should engage with depending on what the practice area is. And then we'll finish off with Q&A at the end. So with that, I will go ahead and kick it over to Ken to tell you about the pros and cons of hourly rates.
Thanks, David. So everyone here is familiar with hourly rates. Most of the work that you do with your law firms is probably done under hourly rates. And obviously there are advantages and disadvantages to all of these things. And everyone's familiar with the advantages. I mean, the billing processes have been out there forever. You get an itemized history, you know, and it works pretty much with any practice group or volume of work that comes through. But there's a number of disadvantages that a lot of in-house legal departments deal with. First of all, and you can see the list there, and I'm just going to talk about the ones in red here today. Fee predictability is something that's really important to a lot of corporate legal departments now, because they're under a lot of pressure, especially now with the COVID situation going on. It used to be that the general counsels got a pass with their departments from the finance teams regarding their budgets. And nowadays, they're being held to the fire like all the other managers in the company to manage their budgets. And so predictability is becoming more and more important for in-house legal departments. The second thing on hourly rates is, the client here carries all the risk, not only of all the costs of the work, but also of a bad outcome. So, even if the outcome goes against them, they still are at the risk of carrying all the cost. And as many people will agree, hourly rates don't encourage efficiency. And in fact, many people would say they actually incentivize firms to be inefficient. Now, it's not that the firms want to be inefficient, but they don't have an incentive to be efficient, like an in-house team where they're being paid a salary and working to get as much work done as possible. And so that efficiency issue really plays into what we're going to talk about here. On the firm side, firms aren't compensated for really high risk, high value work that they provide. So for example, let's say, you're a law firm attorney and you bill out at $600 an hour, and in a 30-minute phone call, you save your client $10 million because you stop them from doing something or you give them some advice. What do you get paid for saving your client $10 million? $300. Okay, so are you really being compensated for that value that you're providing to your client? And then the last thing I want to talk about here on disadvantages is the clients, when you're really looking at hourly rates, everyone is then just focused on the cost and not on the value of the services that are being provided. And everyone's focused on the rates and the discounts and the like, and and the increases in rates every year with the firms. And the whole idea is to get the conversation away from that and really talk about value and results. So Dave, let's go to the next slide.
All right, just before we go into some additional insights into the different fee types, I want to do a quick poll here. So I'll go ahead and launch polling. All right, so if you can please read the questions on your screen here. The first one is, what percentage of your spend is under AFAs? 10 to 20, 20 to 40, etc. Do you get the best value for your money under hourly rates? Yes or no? So we'll just give it another 10 seconds or so for everyone to answer these questions. I know it's really tough. All right, 3, 2, any last answers? Okay, 1, and polling. And now we'll share the results. All right, so it looks like most people are under 20%, Ken, on the percent of spend under AFAs, with 64% of the audience in the 10 to 20 range. And then there's a pretty even distribution after that.
Yeah, and so that's great. And that's about what we see in the surveys and stuff. That there's a lot of surveys out there that come out all the time, with corporate legal departments. The 10 to 20% range is sort of where most departments are. I'm glad to see, and it was interesting there, we've got, 7% doing 80 to 100%.
Wow.
When I left Uber, that's what we were doing also. And, that we're under AFAs. But an interesting thing here, as we're going to talk about it in a minute, is the definition of an AFA, right? And and different people have different definitions. By the way, number 2 there, I see it just says yes, 0, which means I assume that the no is 100%.
Yep. Yeah, best value, it looks like, all respondents said no, that you don't get the best value under hourly rates. So people I think are on your side, Ken.
Totally, yes, great. But really quick, AFAs, and this is my own personal definition of an AFA, anything that really ties back to an hourly rate structure, which is, an inefficient rate structure. And a lot of my clients I talk to right now, say, hey, we've got, some of the really, really big firms are hitting $2,000 an hour. and they say, where does this end? At $5,000 an hour or $10,000 an hour? I mean, at what point does it get to be, ridiculous? And so they're looking for a different way to structure their fee arrangements and the way they work with their firms that's fair to both the firms and to them to the point where they're getting that value. So I think you're going to see this go up and up. And this is really the direction that everything's headed. And some of my large clients, are moving this direction with a lot of their spend, and the firms are starting to see it. So let's go on, David, to the next slide.
All right. All right. So we'll kick off. We'll go through some different fee arrangement types. We'll start with hourly rate fee models. And so capped fee. So this one is where the client would and the firm would agree to a capped budget such that the law firm would bill the client hourly. So the hourly rate here still is really important, because the firm would bill the client hourly up until the cap, upon which after they hit the cap, the firm has to absorb 100% of the overage on the hours beyond the cap. So it's that's the cap fee. And so Ken, could you tell us a little bit more about, do you like this type of arrangement?
Again, this is tied to hourly rates. So even though, people look at this as an alternative fee arrangement, and it is, and it gives you predictability, some predictability, because that, that the cap is there. And so it gives you some of that containment. But, I actually, when I work with my clients, the corporate legal departments, I actually don't recommend that they use this fee arrangement. And the reason is, and this goes back to my law firm side, this puts all the risk of the matter on the law firm. And to me, it's not fair to the firm, because, when they hit that cap, they're responsible for everything past that, but it gives them no upside versus if, for example, a fixed fee. And what happens is that when you look at a fixed fee versus a cap fee for the same matter, you'll often find that the cap fee is higher than what the firm will bid for a fixed fee on the same matter, because they're taking all the risk on a cap fee, and therefore, there's no upside for them, and there's really only a downside if they hit the cap. Whereas on a fixed fee, if they're really efficient and do it well, they actually have a premium they can gain because there's a fixed fee out there. So because of this, the firms tend to set the caps higher than they would if they were doing this under a fixed fee. And then, you get into this issue that if you do hit the cap and it's under a particular matter, and there's still a lot of work to be done, you have all sorts of dynamics that come into play with the law firm where they just say, hey, this isn't working right, or, something's changed here, and, what do we do? And so oftentimes it ends up getting renegotiated anyway if there's going to be a lot of work that goes past that, or it causes all sorts of poor incentives for that firm. So, and again, this is an hourly rate model, and let's move on to the other hourly rate models.
All right. Thanks, Ken. So the next one is the collared fee. So this is in the collared fee, you'd set let's say a fixed fee amount of 100 grand, but it's not a true fixed fee in that the firm is still going to bill hourly. And what happens is if the hourly billings exceed a certain amount above the fixed fee amount, let's say 10%, then the firm would absorb a percentage of those hours beyond the collar. But if the firm comes in underneath the collar, and so we're saying here in this example, let's say you've got a $100,000 fee with a 10% collar around that fee, the firm will bill hourly. If those hourly billings finish within that collar, the firm gets paid no matter what, $100,000. So if they come in at 91,000, they get paid 100,000. So no matter what, as long as they come in within that collar, the firm will get 100,000. If the firm is really efficient and comes in underneath the $90,000, the low end of the collar, then any of the savings would be shared 50-50. So if the firm ends billings at 70,000, the client would pay the firm 80,000 because they're sharing those savings 50-50. If the firm bills beyond the collar, so it bills $120,000, the firm would only get paid 118,000 because there's a 20% discount on all billings past 110,000. So the idea here is that it tries to incentivize efficiency, and does have a bit of a bonus for firms if they're really efficient. So do you like this approach more than more than capped fees, or do you still think that there's some problems here?
So yeah, thanks, David. The issue with this, first of all, with all of these hourly rate models, and there's some other hourly rate models we're not going to talk about today, like blended rates, that some people consider to be alternative fee arrangement. But again, it's it's a blended rate between the associate and the partner rates. And some people also just include volume discounts or tiered discounts as AFAs. Again, all of these hourly rate models require you still to review hourly invoices from the firms. And that review of invoices can spend a lot of time from your in-house team or even a third party if you're using that, and expense and lost opportunity cost for them to do that. So this particular collored fee, basically it's still really just an hourly rate with what I say is a 10% buffer on both ends of it, but you're still basically paying on the hour. It does provide the firm capabilities that if you do go over the cap, like a cap fee, again, which I'm not really in favor of, this does give the firm coverage for that so that they'll continue to work. Now, it gives them more of a discount depending on what the original discount was. So, but those are the different hourly rates models. So let's move to some fixed fee models, David.
All right. Okay, so here's a couple fixed fee models. So the first is a portfolio fixed fee. So this is where the law firm would fix the annual fee for a portfolio of work. And that portfolio of work can include multiple matters. And then the client would bill monthly 1/12, so a pro rata amount of that total annual portfolio fee. And so, for example, let's say you've got a bundle, you've got a whole host of employment litigation cases. You can agree up front with the law firm. Let's agree on an annual portfolio fixed fee of $10 million for all cases in 2019. And then we'll bill, you can bill us monthly on that $10 million. The other fixed fee model is a matter flat fee. So rather than agreeing to a set amount for a whole bundle of matters, you would just agree to a fixed fee. So let's say $1 million in total for the matter. And then that flat fee wouldn't change. It's just you agree to the flat fee amount for the case, and then that's the fee amount that gets billed. Ken, do you want to just go through the pros and cons of these two approaches?
Thanks, David. And you'll notice some structure to how we've put this together here, that we're going to sort of move down in granularity when we talk about fixed fees or flat fees. They're the same thing. We call them both about here. A portfolio fixed fee, it's great in the sense that it gives, great cost predictability to the client, knowing what that is, and, it lowers the administrative burden. And again, because you're on a fixed fee, now you're not reviewing those invoices anymore or dealing with accruals. So there's a big savings there. But the downside for this, it's really hard up front to determine just what the volume of work is going to be in most cases. And here, for example, employment litigation, we don't know how many employment litigation cases you're going to get that year. And so both sides really have risk in here, is that if, it ends up being a lot less work than what you originally thought, then the client's going to feel like they were shortchanged. And if it ends up being a whole lot more work than what they both thought, then the firm's going to feel like they got shortchanged on this. So there's pluses and minuses there. But so you take that and you move down one level, and instead of doing it at the portfolio level, you can look at doing it at the matter level, where you're now paying for just a single matter, a single fixed fee. Again, you get that predictability now at the matter level instead of the portfolio level, which is great. A little more granularity there. But again, figuring out what that scope and the volume of work, and if this ends up completing early, let's say it's a litigation matter, and you say it's like, for example, here, $1 million fixed fee, and then you're 2 weeks into the matter and it settles, then the firm's going to come back and say, well, what's we paid $1 million for 2 weeks of work. So there's issues there too in trying to do this. This one actually does work though for project, and we're going to talk about this in a minute. When you put together actual project work where you have a defined scope and set of deliverables, this ends up being a very good flat fee to use at a matter level when you have specific scope and deliverables assigned and assumptions based on that. So let's move on to the next ones, David.
Okay, one real quick. We got just a quick question on YOY here. What does that mean? So that's year over year. So you lose the billing data, this con on portfolio fixed fee, lose billing data over time and struggle to know when to adjust year over year without shadow billing. So, you know, you've got sometimes, you know, if you've got four straight years, you've got a portfolio fixed fee, all of a sudden you don't have any hourly billing data to compare. So that's sort of a con of, you know, it's great, you know, if you compare the annual fixed fee to what you paid annually last year under hourly, but over time you kind of don't really know how to adjust that portfolio fixed fee unless you're getting some more data. So that's what we mean on that con. See if we got any other questions here. Will we have access to the slides after the webinar? Yes, we will be able to send the slides out after the webinar. And we love these questions, so keep them rolling. You can submit them either through the chat or through the Q&A. So we'll move on to the next slide here. Okay, so the next couple fixed fee models. Number 3, phased fixed fees. So now we're moving from a matter fixed level fixed fee to a phased fixed fee. So this is where you fix the amount for each phase of a matter. The fee is prorated if the case is resolved prior to the completion of a phase. So for example, going back to the case we just had where we had a $1 million fixed fee, now we're breaking that $1 million out to say, okay, well, the fixed fee for the matter is 100,000, or excuse me, is $1 million, but we'll break that out into phases. So we'll do $100,000 for early case assessment, $100,000 for preliminary motions, $300,000 for discovery, $200,000 for pretrial, and then $300,000 for trial. Just some made up numbers there, but you can see how the client would then only pay for the phases that have occurred at the phase level fee that's been agreed. And then the next model here, taking a step towards more granularity, is task-based fixed fees. So then that's where you're getting into specific granular tasks. What's the fixed fee for a patent utility? $12,000. What's the fixed fee for a real estate lease? $5,000. So that's where you'd agree up front. What are the tasks going to be, and what's going to be the fee amount for performing those tasks or deliverables? And then the firm would just bill the client separate line items as those activities are completed. So Ken, do you like the phase and the task-based fixed fee approaches?
Yeah, thanks. So again, we're moving down in granularity here. So the phase fee we're taking, as David mentioned, from a matter level down to the matters broken into phases. Again, you know, it's a little difficult sometimes to know what the work's going to be ahead of time, especially in this case, for example, on litigation. But the advantage here now is, as we said, you know, the downside for the previous one, you know, where it settles early, here you've got $100,000 for early assessment. You know, that's going to happen, you know, up front. And then if it settles during that, then you're only on the hook for the 100,000 now instead of the 1 million. So obviously you're getting, you know, a little bit more granular there, and you're not as much risk for the client to, you know, for the whole fixed fee at that point. So that, you know, that works better. There's a little more work in putting that together and structuring out what the assumptions are and everything else that go into each of those. And then you move down a level into the task base, where you're actually paying a fixed fee for a per task or deliverable. And we have the examples here of a utility patent or a real estate lease. And this obviously gets it even more granular, which is great. And it is able to, the volume, you know, the more utility patents you do, you know, you're paying for them as they go. So both sides are being covered in that way. But again, the volume, you don't know how many you're going to do, so you don't get total cost predictability. But a big issue with this is that it doesn't handle complexity variations or value variations. So, you know, you can have a real estate lease at if it's $5,000, but, you know, is it a real estate lease for just a storefront, or is it for the whole corporate headquarters, right? So there's a huge difference there. So how do you handle different levels of value or complexity in a task-based structure? And so that's part of it. And then also, when you're doing things on very specific tasks, you have what I call the white spaces in between, where you're still doing, for example, status calls with your firm, maybe weekly status calls or strategy calls. Those aren't covered in here, right? Because it's only for the tasks themselves. So how do you manage that? And we're going to talk about how you sort of pull all these together here in a minute, but we're going to talk about two different other types of fees. So let's go on to the next slide, David.
Oh, right. Okay, so the next category of fee arrangement types is the success and contingency fees. And usually, and these can often be coupled with other fee types, which we'll get into a little bit later. But what is a success fee? So success fee is when the law firm will charge a client a fee that is only paid upon the achievement of a predefined outcome. So the success fee is often provided on top of another fee model that it basically gives them a bonus if they achieve the right outcome for the client. So for example, $50,000 success fee for winning a motion to dismiss without leave to amend could be an example of a really tight, well-defined success fee that the client and firm could agree to up front. And so that's how the success fee works. Contingency fee is different in that it's a percentage. So the law firm sets a percentage of the amount recovered in the case. So we all know that, have heard the example of the 30% contingency fee, such that the firm will be billed 30% of all the total amount recovered in the case. And so that, that works well if you're the plaintiff. So Ken, what do you think about these two approaches?
Yeah, so success fees, I use success fees a lot, and I think they're really useful because they're really good tool to align the incentives between the firm and the client and provide a win-win situation. For example, here, the example that David mentioned of a success fee for winning a motion to dismiss without leave to amend with prejudice. So, by doing this, yes, you're paying extra then for winning that motion, but you're not moving into discovery where you could end up spending millions of dollars. So you're having the firm take on some of the risk, especially when you use this in conjunction with either if you're using hourly rates with a very high discount on the front end with a success fee, or you have a reduced fixed fee with a higher success fee where you're going to pay basically a premium if you're successful, and you're going to pay less than you would have normally if you're not successful. And that way now the firm is taking on some of the risk in the matter, which is what a lot of clients want, is to incentivize the firm to do that. The downside to this is that it's not really a downside, but an important point is you really have to define what success means. If you don't have a really good definition of that, when you get to that point, if you just say, we're going to pay $100,000 for a successful outcome, well, I could guarantee you that what the client thinks is a successful outcome and what the firm thinks is a successful outcome are often different. And I've run into this myself. So defining what that is, and you can even get down to a more granular level. For example, on this motion to dismiss, let's say, for example, it's a class action, you might say, just count 3 in the complaint. If we'll pay $25,000 if we can get count 3 dismissed, because by doing so, there's a lot of value in that for us, because it might significantly reduce the size of the class and therefore reduce, the exposure of this particular. So, you can even break it down to that level. And on the contingency fee, most people are familiar with this, 30 or 35%. It's great for clients because, in the sense that they're only paying for that successful outcome. And in a lot of cases, if you're a small company, for example, and it's an affirmative IP infringement case where someone's infringing on your patent, and you're small, you may not have the funds to be able to go out and take this on yourself and take the risk of that. But this is a way that you can actually do that. But the downside to this is that, if the firms get to a point where they think that the value's not there anymore, or the recovery has gotten down there, or the chances of winning, they start losing interest in continuing to do this work. And also the firms, if they don't think that the case is really that winnable or that the recovery is that high, you may not get the firms to agree to actually take the case in the first place. So let's move on then to talk about to the next levels of.
All right. So
Great.
we've gone through hourly rate models, fixed fee models, and success and contingency fee models. Now we want to go over hybrid AFAs as well as value adjusted fee arrangements. So a hybrid AFA is where you use a combination of fee structures. So for example, a fixed fee per phase for each phase of litigation, except we'll use discounted hourly rates for discovery, along with a 5% contingency fee based upon recovery amounts. So that could be a good way to go, because you're coupling the models that make sense in particular areas, and you're kind of aligning the approach depending on what works for that particular case. Value adjusted fees. This is really unique. So I might just let Ken speak specifically to those value adjusted fees. Ken, do you like hybrid approaches versus some of the
Thanks,
traditional
David.
fixed fee approaches?
So what we've talked about up to now are basically just fee structures, right? And they all had pros and cons, and would be good in some areas for good things, some things, and not others. So typically, I end up for most of my fee structures using a hybrid, because there's different parts of a particular matter that might be better to use, a matter-based fixed fee or a phased approach or a task-based approach. So, we have an example here for litigation, with a discounted hourly rate for discovery. You could also take discovery and break it down into a fixed fee per deposition for a fact deposition or a plaintiff deposition or even a 30B6 deposition. And that way, what it's going to be per deposition. So you can basically mix and match and then put in a success fee there, like we said, for discovery or to win at summary judgment or to disallow the class. Those are all different ways that you can manage these. So a hybrid is really where you end up a lot of times when you're being creative and looking at the pros and cons of all these. And the value adjusted fees, there aren't many clients yet that are ready for this level, or even firms, but we have been doing this with some clients. And this is basically where, and it does require good trust between the firm and a partnership between the client and the firm, because what you're doing here is you're saying that the client basically is going to look at the value they think they received and pay for that. And there's a number of ways you can do that through scorecards and through other methodologies, or even, there's some of the more progressive smaller firms now are even just saying, hey, we think this is good. We'll do a fixed fee for 100,000 to do this matter. But at the end, if you don't think the work product we provided or the work that we did was good enough, you can pay less than 100,000. And if you think we did a really great job, you can give us more than 100,000, and we're going to leave it completely up to you. There are some progressive firms that are going this direction, and there are some clients, and I had one client where we did set it up on a scorecard basis that based on specific performance factors, the fixed fee went up or down based upon how the firm performed against those performance factors. And they actually got a premium if they got 5s across the board, and they got less than the fixed fee amount if they got 3s, what the average was. So there are ways to set that up. But what we're talking about so far now, we've all just been talking about structures, different fee structures. But what we haven't talked about is, well, now we've figured out what the structure should be, but what is the right fee that we're going to charge? If we're going to have a fixed fee for something or a phase fee for a particular phase, what should that fee, how much should that be? And that's, everyone talks a lot about AFAs, they talk about these structures, but they don't talk about, well, then when we got the structure, what should the fee be? So we're going to now turn into a whole area about value-based pricing, which is then overlapped on top of using these structures. So value-based fee arrangements, we use those structures we just talked about, but the fees themselves are based upon the matter value. And we're going to talk about that in a minute, about how do you figure out what the matter value is. The type of matter, because there's different values in different types of work. If you're doing, an SEC investigation has a lot more critical value to it, for example, than, that real estate lease that we talked about for a storefront, right? So That type of matter is going to vary. It's going to change what that should be, higher or lower that fee. The firm type, and again, we're going to talk about this, which is what I call the firm price point. You know, the firms have different price points. And if you want to use a very expensive firm to do commodity level work, that's fine. But you got to realize that you're going to pay more. Sometimes I equate it to, you know, taking your car to the grocery store. The Toyota will work great, you know, and the Ferrari you can take too to go to the grocery store. They'll both bring back the groceries. Maybe the Ferrari might not have much room for the groceries, but they both work. But, you know, do you really need to take the Ferrari? The Toyota will work. But if you're going to go out to the racetrack, you're probably going to want the Ferrari, right? So, you know, it's really looking at the firm types and then the jurisdiction, because obviously it's going to be, you know, more expensive to handle something in New York than it is going to be in Omaha or in Europe versus Latin America versus, you know, Asia Pacific and different regions. So the jurisdiction matters, and all of these things come into play. And the goal here is that we talked about before is to pay, when you're talking about value basis, paying more for the results and less for the effort, and encouraging the firms to take on. Now, when you do this, as David mentioned at the very beginning, your counsel spend, your outside counsel spend will go down significantly. And that's because this process is going to force the firm to be more efficient. And it's also going to be done in a competitive process, which we'll talk about in a second. And the positives we talked about before is that you no longer have to do review invoices. And that can be, you know, if you have your in-house team spending 10 or 15% of their time just reviewing outside counsel invoices, you now have a 10 or 15% virtual increase in headcount when they're no longer doing that. Same thing with accruals. Your in-house team, I'm sure, hates you know, going back to firms to ask for accruals if you have an accrual process, and it does give you budget predictability. So let's move on.
And real quick, does this approach work in conjunction with a panel approach? Because I mentioned, going back to your great analogy with the Ferrari, is there a risk of when you put in a panel that you're going to use Ferraris too much?
Well, we're actually going to just talk about that here very soon when we talk about the matter firm value alignment, and that's exactly so a good lead into that, David. That wasn't even planned. That was great. Okay, so we're going to talk about that. So we talked about that matter value estimation, and how do you determine the value of a matter? So there's what I look at is what I call the economic, perceived, and strategic value of a matter. And remember that value is in the eye of the beholder. Okay, what you consider something of value, someone else might not consider to be of the same value. You can go back to the car, you know, analogy. You know, someone might say, you know, a BMW is worth it for, you know, the performance and styling. Other people say, you know, that's way too much money for just to go to the grocery store and back. So different people have different ideas of values. It's what's important is what the client thinks the value is. So the economic value, and let's go back to a litigation matter. Let's say you have a contract dispute they're suing you for $10 million, you know, on a contract dispute. What is the total risk or economic risk or value? It's 10 million. Okay, it's very straightforward. Then I'd go to the client and I'd say, if you lost this case, would you really pay 10 million? And they say, no, that's what they're asking. I say, what do you think the true risk or value of this? They say, maybe it's $3 or $4 million. Is that we're looking at a risk? And then I'd say, and what's the strategic value? In other words, if you lost this case, what's the financial impact to the corporation and possibly the financial impact of future litigation? That could be nothing and it could be huge, right? So you use that in a way, when we talked about it in that last slide about those different pieces of it, that goes into figuring out what that matter value is to figure out, to help you to determine what the actual fee should be. Now, you don't do a matter value estimation for every matter. Smaller matters or you know, lower value or commodity work, it's not worth the effort, but you certainly would want to do this for the larger ones. And then and to get back to David's question, looking at the, you know, putting together a matrix for multiple firms and aligning the matter value with what I call the law firm price point. So basically you don't want your really expensive firms doing commodity level work, okay? You want to align so that your really strategic, high impact work is going to your most expensive firms, because that's, you know, what you're paying them for. And then the more the commodity level work, as we were talking about the real estate leases or immigration work, you don't need your largest firms or most expensive firms to do that. And that sounds pretty natural and normal and makes sense, but you'd be surprised how many companies get into just a regular structure of just doing that because they don't have really a matter intake process to think about, well, this matter, has got a low value. We shouldn't be sending it to, an AmLaw 10 firm, right? This should be going to maybe a regional or super regional firm. So that's, and you can build out a matrix. And if you have a panel, you can even build out that panel by types of matters. And I break it down into 3 tiers. Tier 1 is your high impact, strategic, high matter value matters. I don't use bet the company because they're not always all that. The tier 2 is what I call run of the mill type matters, just your ongoing stuff. And the tier 3 is your commodity, or sometimes in litigation, I call it nuisance litigation work, right? And then you align in that matrix the firms at the price points to do that work depending on whether it's a tier 1, 2, or 3. So when we look at value-based fee structures, using the structures we talked about before in terms of the fixed fees, the different types of fixed fees for litigation, I typically do that with fixed fees and success fees and break it out by phase and break out also at task-based level for specific items. You can still use hourly if you need to, but I very rarely do. And you put success fees in where it makes sense. Sometimes it doesn't make sense to put in a success fee. For example, a motion to dismiss. If motion to dismiss seems like it's a slam dunk, yeah, you're not going to want to pay for that or incentivize a firm to do that because you think that should be, the expected outcome. Transactions also by phase, whether it's an M&A transaction or a real estate transaction or any type of transaction, there's different phases to that. And again, you can do that fixed fee by phase. Discrete projects, I talked about this before. If you have a discrete project, for example, a 50-state survey of a regulatory issue, and you want to go out to the firms and ask this question, you have specific deliverables, timelines, the assumptions that go into that. You can ask the firms for a fixed fee to do that type of work. And then ongoing advice and counsel, use this a lot for corporate work. For example, moving all corporate work to a single fixed fee per month, trademark work to a single fixed fee per month, employment advice and counsel, data privacy and security, IP, all of that advice and counsel work can be moved to by quarter, by month, a fixed fee of work based on a set of assumptions and scope and deliverables, right? And then task-based, we talked about that. For example, here I have patent prosecution is commonly used for task-based only. Immigration work and other things can be set up. And task-based, again, you can break those tasks into different levels of complexity and have different tiers and pricing tied to those tasks. So let's move on to the next slide here.
Real quick before we move on, Ken.
Oh, yeah.
You mentioned ongoing legal work in corporate as a good area. And do you ever use task-based work in corporate for corporate work, like name changes and some of the, or do you think that, because I found that clients often struggle to define the scope of how much work they're going to have in that area. I don't know if you've
yes, and we didn't go into detail on that, but yes, so you can break corporate work into, like, for example, all the 34 Act work, your governance, your board work, derivatives work, treasury work, ERISA work, all that's sort of ongoing, typical corporate work. And then you can break out the stuff that's more ad hoc. So for example, bond offerings or shareholder proposals, they don't happen all the time. The 34 Act work, happens on an annual basis or on a quarterly basis, right? So you know what that's going to be. But there could be other stuff that corporate, and I don't include M&A in this, by the way. M&A is, that's a separate piece and would be done under the transactions type. But you can break that out and ask for a bond offering and a fixed fee per bond offering, right, up front, and say, okay, what would that be? So, but that way, because you don't know if you're going to have any bond offerings that year, or you might have 5, you don't know. So that's a way you can handle that.
Okay, thanks. That's great. All right. Moving on here. So just before we go into some of these final questions, and then we'll close off with Q&A. And so I encourage everyone to stay on the line and raise your hand if you have, if you want to discuss something or have questions. We're going to do one final poll. So why don't I go ahead and choose the second poll and launch this. All right. Number one, do you feel that you get the same quality of work under an AFA as you do under hourly rates? So does the quality of work suffer with an AFA, or do you get the same quality of work? So if you get the same quality of work, absolutely debatable, or no way. No way is, I don't get the same quality hourly rates, I get better quality. When using a fixed fee model, should we ask for a shadow bill? We give it 30 seconds or so for people to finish answering these. And then we'll get Ken's thoughts on this, as well as a few other commonly asked questions. All right, so I'll go ahead and end the polling. Any final thoughts? Okay, no. All right, now we'll share the results. All right, interesting. So do you feel you get the same quality of work under an AFA? Oh, wow, 53% say it's debatable, Ken, whether the quality would suffer. 40% say absolutely, it's great, we get the same quality of work. 7% say no way, hourly rates, you get better quality. Or maybe the no, I actually should have phrased it different. Maybe no way what means AFAs, you get much better quality work. I think I'll work on better phrasing that. So when using a fixed fee model, should we ask for a shadow bill? 47% say yes, and 53% say no, about half and half. Yeah.
Okay. Yeah, thanks, David. And it's good we just asked the poll before we got into this, because I didn't want to give the answers. I put together sort of some of the common questions I do get from clients when we start using AFAs. And the first one is that quality question. And I'm glad a lot of people there said that they do get the good quality, and then sometimes it's debatable. And obviously very few thought it was less. There's a couple things around quality, the quality question. Number one is the areas where you get into trouble with AFAs is when things really go sideways. And if you have a set of deliverables and assumptions and everything goes the way you got it and the firm is bid to that, then you don't run into trouble. Where you get into trouble, and this is where you have to be fair to the firms, when the assumptions change or the scope of work changes and you're under, for example, a fixed fee for a particular matter or a phase, and something happens that neither side really expected, you need to make an adjustment to that. You can't just hold the firm to it, and the firm, because you need to be fair. You want to be partners with your firms, and understand that that they're dealing with the same issue. So that's number one. And the second thing about the quality is, some people are concerned that if they go to an AFA, they're going to get the B team, instead of the A team from the law firm. There's an easy way to deal with that issue, and that is when you set it up, here's the team that is that's accepted by us to do this work, and any substitutions have to be approved by us ahead of time. So that way, you approve that team ahead of time and you don't run into that issue. And then the third thing I'd say on the quality issue is firms are really concerned about their brand. And the last thing they want to do is have one of their major clients start telling everybody what a terrible job they're doing and their quality is terrible. They just, so they will do everything they can to make sure that they're doing high level quality work for their clients, because they do not want their brand to suffer or any individual partner's brand to suffer. So we don't run into that. And there's a number of surveys that are out there now and data that shows that the quality of work does not suffer under an AFA. So that's to answer that first question. And so I was a little bit long-winded, and the second thing about shadow bills, I strongly suggest that my clients not ask for shadow bills. And there's a number of reasons when you're working under, for example, a fixed fee model. When you're paying invoices on hourly rates, and I know this, having worked in a law firm, they go through a pre-bill process where, the relationship attorney or the lead attorney will write down certain hours for associates that spent too much time or for stuff they thought was not relevant, or, make sure that stuff applies to the outside counsel guidelines, and they write, they take all that stuff off. If they're not being paid to those bills and it's basically on a fixed fee, they're not going to spend the time to do the pre-bill work and go through that process. And so these bills then are going to be unreviewed, and they're going to be much higher than they probably would have been if you had done it otherwise. The second thing is that it changes the conversation. The whole conversation you want to have with your clients is, what's the value of the work to me? What do I think, and the benefit I'm receiving, and making sure that what I'm paying is equal to the value. And when you start going back to hours, you're changing the conversation from value back to hours again. And you don't want to go that direction. You want to keep the conversation on hours. And then the third point I make here is, because those are unscrubbed bills, and you're getting these, the hours that are being spent, then when you want to renegotiate, for example, a monthly fixed fee, the year later, they're going to point to these numbers that are much higher than they probably would have been otherwise, to use it as a leverage point as to why the fixed fee should be higher. So those are all reasons that, you don't want to be asking for that. The RFP selection process, I use RFPs, and I know some people are allergic to that term RFP, but you can call it a matter proposal process or whatever. Using a competitive process is really important here, because it makes the firms keep their pencils a lot sharper when they're looking at pricing. If they know they've got the work, they have no incentive to really make sure that their pencils are that sharp. And now when you're doing an RFP, it doesn't have to be these full-blown RFPs that everyone sees with, that are pages long. You can do an RFP in less than a page. And it may just, because if you've already have pre-vetted firms that you've already used before, and you know that they can do this work, and you're just going out to 2 or 3 firms, then it might be just a couple of questions, and that's it. And you could call that an RFP if you want, or just a matter questionnaire. But still doing that. And I also am not a big proponent of sending RFPs out to tens of firms. I don't think that's fair to the firm either. I keep it to a very small number of firms that you think can do the work well, because they do a lot of work to respond to these RFPs, and it's not fair to them if they have a 5% chance of getting this work because there's 20 firms you send it out to, for them to put the effort in. So I really stress that we keep this, to just a few firms that it goes to when you do one of these RFPs. And how do you measure the success of any of these types of models to make sure that you really are getting the value that you think you should be getting against, maybe what you were doing under hourly rates? When I talked about, for example, that corporate work or the trademark work or any of those ongoing fees, that's fairly simple to go back and look at what have you been paying over the years for all your corporate work that you've done, and then compare that to the fee arrangements that you're getting proposed from your law firms. And so that's fairly straightforward. In litigation, because every matter is so different, it's hard to do it at the matter level and say, and litigation, every litigation goes different directions, and they all have different issues, and they could settle, in the very first moments, or they could go all the way through to trial. So you can't really look at litigation in terms of, and I'm talking about complex litigation. When we talk about single plaintiff cases or the more volume-based litigation, that's a different story. But in complex litigation, you can, though, compare the cost in similar types of litigation. For example, on depositions. What did you typically pay for a deposition? And what's the fixed fee that you're going to pay for a 30B6 deposition, or a plaintiff deposition, or a discovery motion? What did you typically pay before for discovery motions, or what did you pay? And then for similar types of matters, you can even look at motion work, like a motion to dismiss. For similar types of matters, what have you typically paid for a motion to dismiss in the past? And then you can compare that, and that's ways you can look at how do you measure success of the engagement. So
awesome. Thank you so much, Ken. This has been really insightful. I'm sure the audience has learned a ton. I know I have from your insights. So we want to open the floor now for questions. And I'd really encourage everyone to click the raise your hand button and then we can allow you to speak and ask your question directly, or you can submit it silently on the Q&A button. We have a question here. One, what does RFP stand for? I can take that one, request for proposal. Without shadow billing, how do you demonstrate continued savings ROI? So yeah, so going back to the measuring part, Ken, if you don't have a shadow bill, how do you determine whether the AFA that's been proposed by a firm is essentially a good proposal?
Yeah, and I talked a little bit about that before. I mean, if you know, for example, on the corporate work what you've been paying in the past, and you'll know that you're getting an ROI. If you've been paying, $100,000 a year for your corporate work, and the firms are that are proposing are coming in at $60,000 for the year for all that work for that same scope, you can see what your ROI is going to be. Then as you go forward, as long, if the scope stays the same, and a lot of times, by the way, for continued savings, I often recommend that you set these up as 3-year contracts so the pricing doesn't change for 3 years unless the scope changes, the scope of work or the deliverables change. And that way, you've got a set ROI that's set in for that period of time. Now, if the scope changes and you have additional things that you're going to add or remove, then you can readjust that fee and do it that way. So there's ways without doing the shadow billing. Now, what I do recommend is, instead of shadow billing, is to ask your firms to give you a list of activities, tasks, and deliverables that they have performed over the past month. Not without the hours and all that, but you may want to know, well, how many depositions did you do? Where are you in the status of that motion? Have you done the research? Have you finished the brief? Has it been filed? All those sorts of things I think are important, and I think you still want to get that information from your firms, but just not ask for how many hours did it take to do that, because everyone knows that hours is not equal to value of results. And what it could take one attorney 2 hours to do, it could take another attorney 5 hours to do. So, it's not always equivalent to the value that you're looking for.
One thing that I would just add on to that is, if you're having a competitive process where you're getting multiple proposals from firms on a matter by matter basis, as you do more of those RFPs for every matter that you're doing, you're going to get a really good sense of what is the market rate for this service. What is the market rate for an employment litigation matter? Because you're going to be getting proposals each time you do this. And so by accepting proposals for fixed fees that are lower than that market average, you're starting to demonstrate continued savings, continued ROI, because you're continually engaging firms and paying a price that's below market. And that's ultimately what matters, is, are you paying a market appropriate fee, based on the firms that you're inviting and the type of work that it is. So that's another way to look at it. Another question here, are there any gotchas we should look out for?
Yeah, I've mentioned a few. I think ones you have to pay attention to, as I mentioned before, is when you've got scope changes and things change. And in litigation, things happen that is unexpected. You've got to then go with the flow and, add additional phases in if, you have an appeal to a motion or something like that. So that's something to pay attention to. The other thing is to make sure that when you're doing competitive RFPs, that they're truly competitive. And that you don't have, the firm, the incumbent firm just thinking, oh, we're just going through this process and it's still gonna, I'm still gonna get it. Because if they have to realize that the work is always at risk, and that they need to really keep in the game. And sometimes, a firm's been around for a long time doing work. They tend to get a little bit entitled to that work. And so it's good for them to realize that, you're willing, it's fungible, and we can move this at any time. So just paying attention to those sorts of items, I think, are important.
Awesome. All right. We got another minute. Thank you all so much for joining. If there are any other questions, if you want to make a comment, please feel free to click the raise your hand button and we can allow you to speak. or again, you can submit those questions on the Q&A. My email address is david@persuit.com. So if you, I mentioned in the chat, if you are interested in having these slides, please just email me and then I can send them to you. I can also connect you with Ken. Ken has actually, if you're interested in Ken standing up, he's great at standing up AFA-based programs for clients. And he's actually helped a client to put together a series of AFA templates that client uses on Pursuit, sends those AFA-based templates out to their firms on a regular basis. So Ken is great at helping to stand up those kinds of programs. So if you're interested in that, please do reach out to us, and we'd be happy to help you with it. With that, I'm noticing, not seeing any other questions. So give it another 30 seconds or so. Thank you all again so much for joining, and I'll stay on the line another 30 seconds or so if there's any other questions.
Thank you, David.
All right. Not seeing any other questions, but thank you all so much for joining. Thanks, Ken, so much this has been really insightful, and we really appreciate you joining. And we'll look out for the next webinar in a couple weeks. So thank you. Actually, I might have one final question coming in here that I may have missed, Ken, which is, what is a shadow bill?
Oh, yeah, I'm sorry. I didn't explain what shadow bills are. Shadow bills are when you're under, for example, a fixed fee where you ask the firms to provide what the hourly, what the amount of hours that they spent. It's like basically getting what the invoice would have looked like under hourly rates. Sometimes it's just hours themselves, or here's what you would have spent, at our hourly rate of such and such. That's what I call a shadow bill. And I'm sorry if I didn't explain that ahead of time.
Do clients can usually have that that shadow bill emailed, or is that something that usually gets submitted? Or I don't know. We don't really recommend. I know you don't recommend. I don't really recommend using shadow bills, but I don't know if you needed to do a shadow bill, do you have a recommended format for doing that? Is it just
typically because they wouldn't be submitted into the billing system that the client has because you're paying it on a fixed fee or different types of fee arrangement. It would be basically attached to the invoice as an attachment saying, here's what, the amount of hours we spent, on this month on this particular matter, here's maybe our hourly rates, and here's how much it would have cost if you had paid this under hourly rates. And it's usually just an attachment in that case.
Okay, awesome. All right. Any other questions? We keep them coming if you've got them. I don't think we got any other questions here. So again, thank you all so much for joining, and thanks, Ken, again. And to everyone, take care and stay safe in this crazy time we're in. All right. See you guys.
Bye. Thanks.